Thank you, Mr. Speaker. I rise to add another voice to those speaking on Bill 4, the Public Interest Disclosure Act, also referred to the Whistleblower Protection Act. Mr. Speaker, the federal government has implemented whistleblower protection legislation, as have many other provincial jurisdictions. Here in Alberta, there is currently no protection for those who blow the whistle in the public sector. I think it is important for our province to follow suit and put a system in place so that if a person working in a public organization has knowledge of wrongdoing, they are not afraid to come forward, they are doing the right thing, and should not be punished for doing this. I have heard a few of my colleagues say that Bill 4 will not really protect whistleblowers, and I tend to agree. Bill 4, as it is written, has no real teeth. Mr. Speaker, let me outline the three biggest concerns I have with this bill. First of all, what this legislation does is tell people to navigate within their own organization when blowing the whistle on the very same organization. I hope my colleagues on the government benches will take a minute to stop and think about what that really means. Imagine that you witness something at work that you know to be wrong. You're an honest person and you know you have to do the right thing and report this wrongdoing and help and promote the public interest. You want to make sure you follow all the rules, so you seek advice on how to properly make a report. How do you get this advice? According to this legislation, you could be forced to submit your request for advice on the proper way to blow the whistle, not to an independent source, but to the very organization in which you work. In other words, your supervisor, your boss, possibly your colleagues will know that you have asked for this information. Talk about a disincentive to even find out how this whistleblower protection even works, let alone actually reporting something. Now imagine that you go ahead and write a report on the wrongdoing that you have this knowledge of. But you're not allowed to blow the whistle to the Public Interest Commissioner, the person who has all the power to investigate. No, again, this legislation states that you must first try to work within your own organization. In regards to blowing the whistle on the very organization, how can the government really think this makes sense? How can they say that this will protect the whistleblower or promote our public interest? Now, there's a provision in this legislation that states if one reasonably believes that a reprisal is likely, he or she can complain outside their organization directly to the Public Interest Commissioner. But will a person somehow have to prove reprisal is likely? And how would they do so? And will complaining directly to the Commissioner really accomplish anything when his power is unchallengeable? Mr. Speaker, if someone is going to blow the whistle, they should have the freedom to do so to any source they determine to be the most appropriate. It is ludicrous for this government to try to legislate how and to whom a whistleblower can take their concerns to. I wonder why this government would even try to be so prescriptive. And the only reason I can come up with is they are trying to make it as difficult as possible for anyone within the government or for anyone within the public service to actually have their concerns addressed, to actually have wrongdoing looked into to promote the public interest. The government claims this legislation provides an avenue for people to blow the whistle on any wrongdoing. But because it is written in such a narrow and prescriptive way, even if a person were to bring forward concerns, it is highly unlikely that the public would ever hear about it. Because this government will not allow individuals to blow the whistle to the media or any source outside the government family. My second concern, Mr. Speaker, is that there is nothing in this legislation, not one phrase, not even one word, about how a whistleblower could obtain a remedy if they suffer reprisals because they have blown the whistle. And let's be realistic here. Most whistleblowers do suffer reprisals. But there are no mechanisms written into this legislation. Legislation that is titled Whistleblower Protection for an individual to seek redress, like compensation for a destroyed career. Again, talk about a huge disincentive to report any wrongdoing. Mr. Speaker, last but not least, I am concerned about how broad the exemptions the Commissioner can make are, as written, Section 31 allows the Commissioner to exempt anything, any person, any public entity, any information, or any record from any portion of the Act or from any portion of the regulations which have yet to be written. Given that this Act provides no method for any decision of the Commissioner to be challenged, not even the courts can be used to mount a challenge, giving such a broad exemption powers does not seem wise and does not seem to be in the public interest. I am not arguing that the Commissioner should not have the authority he needs to be able to deal with concerns that are brought to him. But, Mr. Speaker, there should be some sort of provision for a decision made by the Commissioner to be reviewed if necessary. Yet, this legislation does not provide for that. It does not provide even one avenue for a decision of the Commissioner to be reviewed. How can the government claim that this is transparent? And, Mr. Speaker, not only can no one challenge the Commissioner, if the Commissioner has any concerns, he can only complain to a deputy minister, a minister, cabinet, or an office of the legislature, or to the Speaker. This legislation prevents the Commissioner from going directly to the legislature. In other words, from going to any elected person outside of the Premier's inner circle. And we know their track record. This government does not often walk the talk. They seem to think that providing catchy sound bites without taking any action to back them up is all that is required of them. In the case of Bill 4, the Premier said she is leading the way in terms of accountability. So then, I urge her to work with those of us who have pointed out the flaws in this legislation and challenge her to fix them and make this a great piece of legislation. If she really cares about being transparent and accountable to Albertans, she should be happy to do so. Mr. Speaker, I'd just like to pause and close. In the 6 or so months that I've been an MLA, and maybe being an opposition MLA has something to do with this, the 3, 4, 5, or 6 professionals that have come up to me over the years and wanted to tell, or over this time period rather, and wanted to tell me something, but didn't want it to get back to the government, didn't want their name out, or have started the sentence with, "I shouldn't be telling you this," makes me totally aware of how important this type of legislation is. Thank you, Mr. Speaker.
Thank you, Honourable Member. Standing Order 29-2A is available. Honourable Member for Innisfail, Sylvan Lake.
Thank you, Honourable Member.
Chair.
I appreciate your interest and your speech you're talking here. Would you give your position on whether or not you believe this legislation should be afforded to all facilities that are receiving government money, whether they be public, private, whatever they are, and how you would perceive that could benefit them?
Thank you, Honourable Member. The Member for Cypress Medicine Hat through the Chair.
Thank you, Honourable Member. I, for one, would be concerned about the input into private, but my initial thought is where there's elements of a significant percentage of public funding into where that crosses with private service providers, or where the government, the taxpayer, the citizen is funding things, my initial thought is it should apply because that is public money, and to promote the public interest, that should be protected.
Thank you, Honourable Member. Are there others?